Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. It is cynical. It is an abomination. It is outrageous and objectionable. There is no dispute that it raises serious constitutional questions. It is an unprecedented attempt to thwart judicial review. Now, some people may think that that is actually a judicial opinion, but what that actually is Governor Gavin Newsom and Rob Bonta talking about a law that they did not like that was passed in the state of Texas. What did they decide to do? Well, they decided to go out and pass their own law, kind of as a gigantic middle finger to the state of Texas for some reason, which basically would require anybody who challenged California's gun laws, if they did not prevail 100%, we'll explain that in a minute, that they would owe the state of California all their attorney's fees. This was one of the cases that was stacking up that we talked about on this video right here. And we got a huge ruling again, and it is great news. So today, let's spend a few minutes and talk about another domino falls on gun control. Okay, so the case we're talking about today is listed as South Bay Rod and Gun Club v. Bonta. It's also known as Miller v. Bonta. Now, before we get too far down the road, I want to thank our usual resource down there in the great state of California. That is Costas Moros, Twitter handle right there. I'm telling you, if you guys are anywhere in the country, but especially in California, you need to be following this guy. If you like to use Twitter, he is absolutely keeping you apprised of everything that's going on. I had an opportunity to have a little private discussion with him. There are other attorneys who were part of the successful plaintiff team. They include, of course, Mr. Moros. There was Joshua Dale, Don Kilmer, and Bradley Benbrook. So, for all of you, kudos, congratulations, excellent work. What this is a ruling that has come down. Technically, the ruling apparently came down about 3 months ago, but the parties were still stipulating on some fees that were going to be owed on this thing. And so the ruling now has been made public. What this does is it strikes down California Civil Procedure Law 1021.11. What is that law? Well, it is an absolute abomination, as the governor put it at one point. So here's how the law worked, okay? If you had the audacity to challenge a California gun law, not like any of them would ever be subjected to constitutional scrutiny, but if you challenge that law and you were unsuccessful on any ground, you would then owe the state of California all of its attorney fees and all the reasonable expenses of having to defend it. So, as we talked about in this video right here, you could challenge a law on 4 or 5 separate constitutional and or statutory grounds, have the law overthrown on one clear violation. The court could rule against you on the other 4, but it doesn't matter. The law has still been struck down, and under this rule, you still owe Rob Bonta and Gavin Newsom all of their attorney's fees. Now, how bad is this law? This law is so bad that the court has found that it violates not 1 but 2 constitutional amendments as well as federal statutes. Now, California, you may remember that this civil procedure was passed through Senate Bill 1327. It was in response to a Texas abortion law. So, I just want you to know, I don't know how many hundreds and hundreds of thousands of dollars that your governor and attorney general has cost the taxpayers of the state of California, but this was literally passed out of spite for some law on a completely unrelated subject in another state. This is how the court started off articulating all of the deficiencies in striking this law down. The principal defect of Section 1021.11 is that it threatens to financially punish plaintiffs and their attorneys who seek judicial review of laws impinging on federal constitutional rights. Today it applies to Second Amendment rights. Tomorrow, with a slight amendment, it could be any other constitutional right, including the right to speak freely, to freedom of the press, to practice one's religion, to restrict cruel and unusual punishment, and to be free from government takings without compensation. And in finding that this violates the First Amendment, as well as the Second Amendment, the court was quick to point out the unique and very important bond between those 2 constitutional amendments. In our ordered system of civil justice, the Second Amendment right, and for that matter, all constitutional rights, are ultimately protected by the First Amendment right to identify unconstitutional infringements and seek relief from the courts. And I believe it's actually a more symbiotic relationship, because I do believe without the right to defend ourselves, the right of self-preservation, not the right of self-defense, the right of self-preservation, then all of our other constitutional rights would surely be taken from us as well. But you see, in addition to that, the court found that, oh yeah, you know what, this violates due process, this violates equal protection as well. So this may be one of the worst statutes ever drafted. As the court put it, without this guarantee that one may not be deprived of his rights, neither liberty nor property, without due process of the law, the state's monopoly over techniques for binding conflict resolution could hardly be said to be acceptable under our scheme of things. And in fact, the court is meant to resolve disputes. That's their sole purpose, and the court even recognized courts are the central dispute settling institutions in our society. They are bound to do equal justice under the law to rich and poor alike. They fail to perform their function in accordance with Equal Protection Clause if they shut their doors to indigent plaintiffs altogether. Where money determines not merely the kind of trial a man gets, but whether he gets into court at all, the great principle of equal protection becomes a mockery. And this is exactly what the state of California was doing, is they wanted to make it so cost prohibitive to even attempt to challenge any one of their unconstitutional gun laws that law firms, such as the ones that did all of this amazing litigation in this case, would be unwilling to assume the risk of accepting this type of litigation. And that is exactly the chilling effect that Gavin Newsom and Rob Bonta wanted on the legal community. But there was other problems as well, including the violation of 42 United States Code Section 1988. Now, without getting too far into the woods on that, the way it worked, as we already explained, is, hey, listen, if you challenge a law on 4 grounds, and you prevail on the first ground, and even though you lose on the other 3, the law gets struck down, no, you're still owing the state of California money. And so, therefore, you would always be the loser. This is how the court put it. California's fee-shifting provision turns this approach upside down. A plaintiff who succeeds on the merits is never a prevailing party. Government defendants may be entitled to attorney's fees from plaintiffs even where the claims asserted are not frivolous. Anything less than complete success for a plaintiff becomes a win for government coffers. And in concluding, what a horrific piece of legislation this was, the court commented, a state law that threatens its citizens for questioning the legitimacy of its firearms regulations may be familiar to autocratic and tyrannical governments, but not American government. And whether that is true in California or not, I think the jury is still out on that. Now, here's the big news, okay, and this is the important part, is that this law has been permanently enjoined, okay? That means this law ceases to exist effective immediately. The court specifically found the plaintiffs have satisfied all 4 factors needed for entitlement to permanent injunction. The provisions of the Constitution are not time-worn adages or hollow shibboleths. The court declares California Civil Code Section 1021.11 to be unconstitutional and permanently enjoins the defendant from bringing any action or motion under Section 1021.11 to obtain an award of attorney's fees and costs. And, of course, that was signed by the Honorable Roger T. Benitez. If you're not familiar with who Judge Benitez is, don't worry. In the next few weeks, you will become quite familiar with him. Listen, I want to congratulate Mr. Moros and all of his co-litigants down there. It is amazing work. You guys should all be proud of yourself. If you're down in California, find those guys and buy them a drink. Hey, in the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you should know how to contact Washington Gun Law by now. But if you don't, all of that information is in the description box down below. In the meantime, I want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.